All right. So welcome everybody. We have a really important presentation that we're doing today. We're joined by Lindsey and Veronica Welsh from Shawe Rosenthal. And Shawe Rosenthal actually writes our Maryland Human Resources Manual for us. And Lindsey has been here, I think it was like 6 years ago to do this presentation. When I noticed that there's tons and tons of views on our YouTube channel, I invited them to come back to do an updated presentation because it's definitely time, and this is a huge topic. So I know we have a lot of new people, clients of Veronica's and Lindsey's, so I'm just going to do a really quick intro to HR Simple, and then we'll get started. So HR Simple works with top law firms around the country like Shawe to publish HR manuals, state-specific HR manuals, print and digital. And we also have this webinar series that we do monthly. We used to do one a month, but there's too many topics to cover, so we're doing 2 a month now. We actually have one next Wednesday about the brand new Secure 2.0 Act and what that means for employers. So you can go to hrsimple.com/events to register for that. And then if you have questions during the presentation at all, you can stick them in the Q&A box below. We'll try to get to as many as possible. And everybody can expect a follow-up email tomorrow with the recorded presentation and a copy of these slides and the credit codes. So with that, I'm going to turn it over to Veronica and Lindsey. Welcome, guys. Thank you for joining us.
Thank you. Hi, everybody. My name is Lindsey White. I'm joined by my partner, Veronica Welsh. We're very excited to be here today to give you an update on EEOC investigations and litigation. And Amy's right, I did this presentation several years ago, and many things have changed with the EEOC. Many things are the same, but we've had an entire pandemic. We've had work from home. We have new initiatives from the EEOC. So we're going to dive in and cover a lot of different topics today. A little bit about our background. Next slide, please. So we are both partners at Shawe Rosenthal, which is a labor and employment boutique in Baltimore, Maryland. We have clients all over the country, and we help them with a variety of employment issues as well as traditional labor work, such as collective bargaining and labor arbitrations. Before I joined Shawe Rosenthal, I was a trial attorney with the EEOC for many years and also did a detail in the chair's office. At the time she was a commissioner, now she's the chair boroughs. And that experience has been very helpful in my practice now, defending employers and working on compliance. And I'll share some of, some of those insights that we have from the EEOC from that time as well. And Veronica's practice also focuses on employment, and prior to joining us, she had a varied litigation background, so has a lot of different experience litigating different cases, including, of course, employment cases. And we're very happy to take questions throughout the presentation. And you can, I believe, Amy, jump in if I'm wrong, but I believe you're supposed to put them in the Q&A box, and we'll certainly get to all of those. Okay, so to get us started, we have this disclaimer. These are, the materials are for informational purposes only. This is not legal advice. So we're just giving you some information, and we'll talk a lot about trends and some tips throughout. So what are we going to cover today? We're going to talk about the EEOC process. I'm sure many of you on this call are either in-house counsel or HR professionals, and you're familiar with the process. So we're starting from that base of understanding, but we'll walk you through the life of a charge and things to include in the position statement. We'll talk about subpoena enforcement. We're also going to talk about EEOC charge data and statistics, so you can see what the trends are. And spoiler, they're very interesting trends over the last 5 years. We'll talk about the EEOC's priorities, and we know these priorities because they're publicly available. They are available through the EEOC's strategic plan, as well as the strategic enforcement plan, which is currently in draft form, but will probably look very similar to the draft. And then we'll talk about the investigative process. If you're unlucky enough to be on the other side of EEOC litigation, we'll talk about what that process is like, as well as some of the cases the EEOC has brought lately to give a sense of the priorities. And then we'll take Q&A. Okay, so what is the EEOC? It's the federal agency that's responsible for enforcing the country's anti-discrimination laws. And those prohibit discrimination on the basis of sex, race, color, religion, national origin, age, disability, and genetic information. And these apply to almost every employer across the country unless the employer is very small. And the laws apply in all different contexts with respect to hiring, firing, promotions, pay, reasonable accommodation. So it's really all aspects of the employment relationship. So let's talk about what's happened since in the last 5 or 6 years with respect to the number of charges. So as you can see from this graphic, the number of charges, if you go all the way back, to 2006, the charges were rising and rising and rising. But something very interesting happened when the more recent charge data came out, which is since 2016, there is a decline in the charges that have been filed. And you'll get these slides tomorrow. I wrote a blog about these trends back in December, but it's striking that there are 30,000 fewer charges filed in the past fiscal year than there were in 2016. And, when I first started thinking about why that could be, I thought, well, maybe it's the pandemic, but then no, the pandemic didn't hit until 2020, and we were well on that downward trajectory by then. So really, and there's no way of knowing if this is true or not, but what I really think this is I think you can probably link it to the Me Too movement, as well as in some way the pandemic in the later years. But I think you can link it to the Me Too movement. And what we're seeing anecdotally is a surge of internal complaints, internal investigations, sometimes demand letters, but we're seeing a lot of pre-charge activity that's being brought to employers before it goes to the formal process of filing a charge, which I happen to think is a really good thing. It means that people have effective policies and that employees are coming forward, and hopefully it gives the opportunity to resolve these disputes or issues prior to a more formal litigation posture. So it'll be interesting to see as people have really returned back to work. Those industries that were remote during COVID have returned back to work. If the charges will creep back up a little bit, my prediction is they're going to creep up a little bit, but they're probably not going to creep up all the way back to where they were. And the charge data is broken down by types of discrimination. Even though the number of charges have dropped, the percentage of the charges and what is alleged in the charges has remained very stable, except for retaliation, which continues to go up and up. And that's just something to be mindful of. There are many situations where the underlying discrimination is found to have no merit, but there is retaliation that can be a real problem because it is much easier for employees to prove retaliation. Okay, so let's talk about these two different plans, and they sound like they're the same thing, but they're actually not. There's the strategic plan, which is already in place for 2022 to 2026, and the strategic plan articulates the Commission's priorities to advance its mission over the next 4 years. And again, we have a hyperlink there for folks to access the plan if they want to dig deep. And under the strategic plan, there are 3 strategic goals for the next 4 years. 1, to combat discrimination, which makes sense. That's the goal of the agency. 2, to improve education and outreach. Folks might not know this, but the EEOC does do a lot of speaking itself and education to try to give information to the business community, to employers, to employees of their rights. And then 3, strive for organizational excellence, which I think is really more of a kind of housekeeping, internal accountability type of goal. So the first item is really, I think, the real meat here, and it's really what the agency seeks to do, which is combat discrimination. And there are a lot of different ways that they do that, but one important part of that is the EEOC's systemic program. And what does the systemic program mean? That means systemic cases are a pattern, practice, policy, and/or class case where discrimination has a broad impact on an industry, profession, company, or geographic location. This program was created in 2006, and it is, there are typically people in each office, lead systemic investigators who handle these types of cases. They're trained in a specific way to investigate them and develop them. And then many of the attorneys, litigate these types of cases. And when the EEOC litigates a systemic case, it is very common to draw attorneys from across the country to be pulled in. And this, dedicates, there are a lot of personnel that are dedicated to these types of efforts, even though in terms of a percentage of litigation, it makes up about 11% currently, so not a huge percentage, but it is a big focus. And the types of cases or charges that you would see fall under this category are things like failure to hire women to be truck drivers. That could be a systemic, class case. You also see sexual harassment if it's widespread. Could be a systemic case that affects a lot of different people. Any kind of policy that could have a disparate impact or have a discriminatory effect on people, such as the requirement that somebody be fully healed to return to work, or a maximum leave policy where somebody's ADA leave is cut off once they hit the 6-month mark without any consideration or further dialogue. Next slide, please. So I say this, and this could be its own presentation. It's just important to think about if you receive a charge that has allegations that could lend themselves to systemic claims, if it's about a policy that you have, or there's a large group of people affected, you really want to be thinking early on, what can we do to mitigate this risk? And that's, that should raise your antenna of, what to do. And, definitely involve counsel early on that. And these investigations can take a very long time. They can be very costly, multiple requests for information, including electronically stored information. Okay, next slide. So between 2019 and 2021, there have been over 1,000 successful systemic resolutions. And a lot of these cases are resolved before they ever see the light of day. So they're resolved in the investigation stage before before it becomes public. And I think that's in large part, because employers know that it's going to be really costly to litigate, it's time intensive, even if you ultimately prevail. You're looking at 5+ years of litigation. And this is a pretty staggering statistic. In 2021, the EEOC resolved 342 investigations, systemic investigations on the merits. On the merits means there was some sort of cause finding, and obtained more than $24 million for those that were affected by the discrimination, 21 million from conciliation alone. Okay, this is a somewhat dated statistic, but I would guess the percentage is about the same. As of 2016, the systemic litigation program, when it goes to litigation, has achieved a 94% success rate over the past 10 years since it started in 2006. And resolutions can often be in the high 7 or in the 7-figure range. Okay. So I talked about this a moment ago, but these are really the types of charges that lend themselves to becoming a systemic investigation, a pattern or practice, a facially discriminatory policy, a facially neutral policy that has a disparate impact. So that could be something like an attendance policy that doesn't factor in protected leaves or leaves under the ADA. Okay. Okay, the second priority, just briefly, is education and outreach. And the EEOC is really trying to do outreach to underserved communities. So, low income workers, younger workers, teen workers, that's a big source of outreach to make sure that they understand their protections. Workers who do not speak English as their first language, those are all very high priorities for the EEOC. So the strategic enforcement plan, that is a different plan, and that really articulates the EEOC's priorities with respect to investigations and litigation. So that's more detailed in terms of it gives employers a blueprint for the next 4 years. This is what the EEOC is going to target. And it's currently in draft format. So if you were so inclined, you can submit a comment. If you think that the priorities should be different, or you have, any other commentary. Okay, so here are the 6 priorities, and we'll talk about each of them in order before I toss it over to Veronica to talk about the mechanics of the EEOC's investigation. So some of these are the same as they've been in other past years. So the first is eliminating barriers in recruitment and hiring. So this is one that we saw last time, but interestingly, the description is a little bit different. So the EEOC is really, really focused on employers' use of artificial intelligence and algorithmic fairness in the workplace. So there is a special initiative that was announced in 2021. There have been public meetings. There's been guidance now. There's guidance out there on the EEOC's website that talks about disability discrimination, in particular with respect to AI and use of these programs. So if you are somebody that uses these programs, you really need to be careful and make sure that you're doing it in consultation with counsel. In particular, there are many new laws across the country that dictate this as well. New York City is kind of the landmark one, but it's an emerging area. But this goes to really any barrier that you could think of in recruitment or hiring, criminal and credit background checks, anything that has a disparate impact on older workers, medical questionnaires that would screen out individuals with disabilities, that kind of thing. The second priority is protecting immigrant, migrant, and other vulnerable workers. So those are, older workers, low-wage workers, teenage workers who might not know their rights in the workplace yet, LGBTQ individuals, all of those types of things. This is another priority that we've seen consistently. We saw in the last strategic enforcement plan, for example. The third topic is addressing selected, emerging, and developing issues. And this is, again, a repeat, but it allows the EEOC to be nimble and focus on events that they could not have foreseen at the time they put together this plan. So for example, 4 years ago, it would have allowed them to really address the COVID-19 pandemic. And here they make a point to mention technology-related employment discrimination. So that is, again, another factor. You also see pregnancy discrimination listed in this topic as well. Any global events that impact people. So when COVID-19 originally hit, we noticed the Asian American communities were targeted as a backlash. Same thing happened with 9/11 and Muslim communities. So that's the type of discrimination you'd see as a priority here. The fourth one is advancing equal pay protections. Again, this is was in previous plans. And it goes to equal pay, not just on sex, but really all bases. Okay. it remains a tremendous priority for the EEOC. They did have, you might remember, the data collection for pay bands that has not continued on. We don't know if that's going to be reinstated at some point, but the EEOC is always looking for ways to figure out how to best enforce the Equal Pay Act. Okay, next is preserving access to the legal system. And we've seen a lot of these before. It's arbitration agreements that are unenforceable, overly broad waivers or releases of claims. So you always want to make sure you have your EEOC carve outs when you have your severance agreements, failure to keep adequate records. So when the EEOC investigates, they have access to those records, those types of things. And then the final one is preventing and remedying systemic harassment. And harassment is one of those topics that is of constant interest to the EEOC, I think for a couple of reasons. There are always a lot of harassment charges. And I think everybody can agree that harassment is, entirely unacceptable. And it's sort of a good priority to focus on. So there have been many initiatives to this effect, including a study on harassment and a best practices document that the EEOC published as a result of that. So with that, I'm going to turn it over to Veronica.
So I wanted to just give you an overview of where we're going next. And so this is kind of the life cycle of a charge from intake to litigation. And I'm just going to briefly, discuss each, but we'll definitely take a deeper dive into these as well. Intake, that's the charging party's initial inquiry to the EEOC, as well as the EEOC's evaluation of the facts and the documents that the charging party may provide. And based on that information, we get the charge of discrimination, which I'm sure many of you are familiar with. Definitely going to talk more about that. But based on the contents of the charge, we go to the EEOC's investigation process, which starts with the position statement, some requests for information, additional requests for information, possibly subpoenas, site visits, and witness interviews. So we're going to talk all about that. At the conclusion of the investigation, or at other times, which we'll discuss, a notice of right to sue is issued to the charging party by the EEOC, and this triggers their 90-day time period to file a lawsuit. And like I said, this could be issued at the conclusion of the EEOC's investigation, if it's been longer than 180 days. It could be any time after 180 days where the EEOC determines they're not going to finish their investigation. Let's issue the notice of right to sue. Or if 180 days has passed, the charging party can request a notice of right to sue, and the EEOC is obligated to provide it. Something we've seen recently is that the EEOC is issuing a charge and then shortly thereafter issuing a notice of right to sue. They may do this if they don't think they're going to be able to finish their investigation timely, but it's required through the administrative process that a charge pend with the EEOC for 180 days. So there is an argument if the charging party takes that notice of right to sue and files a lawsuit, that lawsuit is premature. Now, the courts across the country are split on this. Even the courts in the District of Maryland are split on this issue. But it may be worth making the argument. We were recently successful in arguing that a charge that only pended for 2 days was premature to file a lawsuit, and the court actually remanded that case back to the EEOC for processing for another 178 days. So it's something to consider. And then if a notice of right to sue is not issued after the investigation, the EEOC may approach you about conciliation, which is an opportunity to resolve the matter prior to litigation, which we'll talk about later. And then if all else fails, the charging party could file a lawsuit, or the EEOC could elect to proceed with litigation. So what triggers an investigation? Obviously the charge of discrimination, and most of these charges are filed by individuals. And we will also talk about commissioner's charges and directed investigations later in our presentation. But I kind of alluded to this in the beginning. How did this charge come into existence? And that's the intake process. The claimant, since we don't really deal with that, I'm just going to quickly talk about what that looks like. But the charging party will fill out a pre-charge inquiry form with basic information. They may provide documents. The EEOC may interview the witness one or maybe multiple times. And all of this information then gets taken by the investigator to form the charge. And it is worth noting that this pre-charge inquiry or initial process is not a charge of discrimination. In order for the charge to be perfected, the charging party has to sign and verify that the contents of it are correct. So once that information is collected and put into a draft charge, the investigator sends that to the charging party, and then they will sign it, and it becomes a perfected charge. So are all charges created equal? I think we all know the answer is no. But in navigating and handling all of these various charges, the EEOC prioritizes the charges into A, B, and C, A being the most serious in the sense that the EEOC thinks that there likely will be probable cause. A B charge might be something that requires further investigation to really understand the merits. And then a C charge would be those that, based on their face and the information that the EEOC has, these might not really have merit to them and will likely be dismissed. So once the charge is perfected, the EEOC does have to provide notice to the respondent within 10 days. And I'll just note, while you aren't told if your charge is a priority A, B, or C, based on how the EEOC begins its investigation and continues to pursue the investigation, might give you a heads up as to where your charge might fall. And we will talk about some of the red flags that might pop up during the investigation process.
Right, like being asked for more information if you've just submitted your position statement a week ago would not be a good sign.
Right, there's a few red flags that we'll talk about. That's just one. But some initial steps that employers should take, it's very important to retain relevant documents. And the need for this is twofold. One, you're going to need those documents to support your position statement or your position that you take in this case, whether it be in mediation. And contemporaneous documentation really is the best evidence in responding to a charge. There's also the obligation that employers retain documents once they're put on notice of certain claims. So there's kind of two reasons to pay attention to this. Second, you want to conduct, I'm going to call it a mini investigation of the charge allegations on your own. So that means reviewing and collecting relevant documents, speaking with relevant witnesses. And you do this in order to kind of evaluate your options. Do we want to mediate early? Do we want to submit a position statement? What should be included in the position statement? It kind of dictates your strategy as you move forward. Okay, so we get to the EEOC investigation process, and there's a few pieces of it, and here's an overview. But requests for information can be very preliminary, and so we've been seeing those issued along with the charge and the request for a position statement. And the preliminary requests are really looking for basic information like the personnel file and the employment policies that might be relevant. We'll talk a little bit more about that. Then there's the request for the position statement, which is your opportunity to really debunk plaintiffs, or excuse me, charging parties' allegations and reframe the facts and law in a very persuasive way. It's really like a piece of advocacy and your chance to submit your position statement in a clear and articulate manner. A well-written position statement is powerful, both during the administrative process and in subsequent litigation. And after you submit your position statement, like Lindsey was saying, the EEOC might request on-site tours or walkthroughs of your facility, as well as interviews and then subpoenas. And if we get to that part, it's most likely that this is a higher priority charge. So before we get into all of that, it is worth noting mediation. If you've logged on to your respondents portal ever for the EEOC, you might see that there's a little box there asking you if you're interested in mediation. Not every charge has this election, and it's also worth noting that both parties have to agree to mediate. If you aren't initially offered mediation, you can always reach out to the EEOC's mediation team and request it. And in common practice, they'll say, okay, let me ask charging party, and they'll call the charging party and see if they're interested. And so you might have another opportunity to mediate, even if it's not directly on the portal. So why request mediation? I mean, there's a lot of reasons, which we're going to talk about, but some of the obvious reasons that an employer might not want to engage is that the EEOC is going to expect you to offer something, usually money, to resolve the case. So if for some reason the employer just feels like they don't want to set the precedent, that they'll settle nuisance cases, they may not want to go to mediation, but it's often, if possible to resolve at this stage, the most cost-effective approach. So some of the pros you'll see here, the mediation program has a 70% success rate. The mediators are really helpful in facilitating resolution. This also brings finality to the charge and any other potential claims that the charging party may have. So there is the benefit just to be done and get a settlement agreement and move on. Free discovery. This whole process of mediation gives you the opportunity to hear plaintiff's side of why they believe they have a claim. And it can give you insight into what's driving their desire to proceed with the charge. So you can obtain certain information that you might not have been able to get through the position statement process.
And can I chime in for 1 second? So I had an EEOC mediation recently, and we learned some more details about the allegations, and what we learned, I was able to conclude that it would be very hard to get summary judgment because there's going to be verbal communications at issue, which the charging party can prove through their own testimony. So that actually led us to decide that if we could get what we perceive to be a reasonable settlement, that it would be worthwhile for the cost of litigation. So that goes to your point, Veronica, about the free discovery. It also helps you better evaluate the charge, especially if you don't understand a lot about the charge, if there was no internal complaint before.
Yeah, and another good tip is once the mediation date gets set in, especially if the charging party is pro se representing themselves, you can actually engage in early settlement discussions, and you could resolve the charge without having to go to mediation, but you can also test the waters as to whether the charging party is going to be reasonable at mediation, and you can see if they give a really high demand, their mediation might not be effective or successful, but if they give a low demand, it's a great starting point to say, okay, this is something that can be resolved. Okay, so position statements. Like we said, these are very important and they are a statement on behalf of the employer. So you want to make sure that they're delivered clearly and persuasively. So these are some of the sections that we think are important to include. One, you should have a statement of your employment policies that are applicable to the claim, which demonstrates the employer's commitment to EEO. You should also have a detailed fact section that responds to each allegation, but also provides your explanation and any other facts that might be relevant to the claim, along with supporting documents. And then you use those facts with the case law to frame a really persuasive argument as to why the charge lacks merit. And it's important, especially in complicated charges, that you involve your attorneys. They might be able to evaluate what facts should really be included, what documents should not be included, and make a calculated strategic decision on what to include. Like I said previously, all of these statements are a position statement is a statement on behalf of the employer. So if you end up having to go to litigation and you offer a different explanation for an employment decision that was different than what you had in the position statement, that could be potentially evidence of pretext. So you do want to strongly consider involving your attorney. The EEOC also provides position statements now to the charging parties, so it's likely that they're going to see what you set forth in the position statement, which may dissuade them from filing a lawsuit after, and give them more to think about their claims. So a key takeaway here is do your mini investigation, fully evaluate your claims, and make sure you're putting forth a strong position statement. Okay, so I talked about these earlier. We have the standard request for information, and usually the EEOC does request those to be returned pretty quickly. But in our practice, you can usually incorporate that request into your position statement and let the EEOC know that this position statement and the documents we're providing are responsive to the request for information. So you can kind of handle those together. The more problematic requests for information are the ones that come after the position statement, or even from the outset, that are more detailed and are asking for charge-specific information. Those should be definitely a red flag that the EEOC is looking closer at this charge. So you might say to yourself, do I have to provide this information? Can I push back? And at this stage, it's definitely worth trying to negotiate with the investigator to narrow the scope of the information that they're requesting, because I can guarantee you that it is overbroad in some regards and that there is wiggle room for you to negotiate with them. We'd argue that not providing any response is not going to be helpful for reasons we will discuss in these next slides. So another somewhat pitfall is if you provide the EEOC with additional information and don't narrow the scope or don't take efforts to kind of give them the information that they're looking for, it could expand the scope of the investigation. So this is a reason to push back to some degree, because you want to make sure that you keep the investigation as narrow as possible. And in the event that they do expand the scope of the charge and the investigation, you will receive notice from them with their basis for doing so. So subpoenas. If the EEOC tries to get information from the employer and they're unable to do so, they have the authority to issue a subpoena to obtain that information. And if the employer still doesn't give them the information, they can take that to a court and ask for the subpoena to be enforced. So if you get to this stage, it's definitely a more costly process, and you're now facing a court saying you have to adhere to the subpoena requests. This statutory section also gives the EEOC very broad authority to investigate and use a subpoena to obtain relevant information. And the scope of that relevant information is very broad for the EEOC. So if you get a subpoena, you have a few options. Respond to the subpoena as is, petition to revoke or modify the subpoena to the EEOC, and then you can partially respond and not respond and see if the EEOC moves to enforce. So you have a few options.
And just a quick point, the EEOC is not going to issue a subpoena without issuing a request for information and trying to get the information that way. So to Veronica's point, when you get something like that, you really do not want to ignore it. Usually you can negotiate the scope and reach agreement. But as a last worst case scenario, the EEOC will issue a subpoena, and then, as Veronica's about to tell you, you're going to end up in court.
So if you decide that you're not going to respond to the subpoena, you have 5 business days to submit a petition to revoke or modify the subpoena to the EEOC's legal department. And they can decide to fully uphold the subpoena, narrow the scope of the subpoena, or invalidate the subpoena, which is very unlikely. But this is an avenue you can take, and you need to be aware of this 5-day rule so that you can timely submit your petition. Once the petition is ruled on, the EEOC legal unit will give some time for compliance, but if you fail to comply, they will move for enforcement in district court. So you might be thinking, well, should I comply or should I just let them take this to court? And that's something you have to weigh and consider, but you should know that given the broad authority to the agency and the court's deference to the agency, there's a high likelihood that at least a portion, if not all, of the subpoena will be enforced. And the process of fighting the subpoena may not be cost effective. So that's something that your attorney will have to speak to you, or you internally have to decide whether that is worth pursuing. You should also research the case law in your circuit and see how the courts in your circuit handle objections to subpoenas. So the Fourth Circuit here, this is from a case involving a subpoena, objections to a subpoena. The Fourth Circuit said that it will defer to an agency's own appraisal of what is relevant, so long as it is not obviously wrong. So here we're seeing a strong deference to the agency and for them to use their expertise to determine what they think is relevant and what is not relevant. So given this great deference, the court's role in enforcing the subpoena is very limited. And so they're really not looking at the merits of the case. Even if you have a great defense, they don't want to hear about it at this stage. They're just trying to determine whether the EEOC has the authority to seek the documents and information and whether that information is relevant. Another argument that you could advance in fighting a subpoena is that it would be unduly burdensome to provide the documents. And this is a high hurdle and very difficult to meet. To show this burden, an employer has to show that the production would seriously disrupt its normal business operations. A factor that they look at is what is the cost of production compared with the ordinary operation cost. So if you think of a large organization, they'll have a very difficult time saying it's overly burdensome, unduly burdensome to produce these documents when their operation costs are very high. So this is an avenue that I would not rely on, and it's very difficult to meet.
Just to chime in on that, I mean, the courts really reject anytime an employer makes a facial argument about undue burden if they don't have supporting documents. So, you know, if this is an argument you're going to make in court, you're going to have to support it with evidence and be really thoughtful about it. And the larger your operations are, the more difficult it's going to be.
So let's move away from subpoenas for a minute, which, as you can probably tell, each of these topics can have its own hour to shine. So we're just trying to give you a high-level overview here. But on-site visits can involve a tour of the premises as well as interviews of the witnesses. This part of the investigation, again, is the EEOC has the authority to do them, so you should be cooperative, but prepared. So you should take maybe track the tour of where you would bring the EEOC investigator, prepare your employees and managers to answer questions from the EEOC, especially the ones that you can identify will be likely targets for an interview from the charge allegations. You should also be aware that your management employees can bind the company in what they say. So preparation is very, very key. And it's also worth noting that a well-prepared position statement could possibly avoid these types of further investigation. So you want to make sure that you're providing, enough information there where maybe this won't be a necessary next step. During interviews, attorneys or representatives have very limited roles in what they can say or do when a witness is being interviewed. We typically recommend only to object based on privilege, or if you can offer some helpful clarifying information to the investigator that you think would be helpful and not overstepping, you're welcome to do that as well. They may also ask for your consent to record the interview, which is usually so that it can help them and they don't have to take notes after the fact. And typically that's something you should be cooperative with as well. And if you even feel necessary, you could reciprocate and ask for the interview to be recorded on your end as well. But regardless, very detailed notes should be taken during these interviews and kept in your file. To the extent the investigator wants to interview non-managerial employees without a representative there, I think you should be ready to advocate that your attorney represents all your employees and you want your attorney to be present. But again, that's something that they might want to do, and you should be cooperative to the extent possible. Also, during these on-site investigations, you might be able to gain some insight into how the investigator is leaning regarding their investigation and the charge allegations. So it might be helpful when you have those discussions or kind of see their body language as they interview witnesses.
All right. Thanks, Veronica. That was really helpful. One thing, just a final point on the on-site investigations, we are not really seeing a lot of those since COVID has hit. Veronica, have you had any? I've not had any since COVID, right? So, I think the EEOC investigators are just starting to return to the office to take in-person intake. But one of the things that the investigators are judged on in terms of performance can be, certain cause findings. So it's, the technical violations. If you don't have the right posters up, and there was a new EEOC poster that just came out in the last couple of months. So if you don't have the right posters up, if you don't have your records properly kept, if you are commingling medical and personnel files, which is not allowed, those are some of the things that they might check for on a routine basis at an on-site. So if you are having somebody come on site, I always advise that clients make sure that their house is in order and that they're in line with that, in addition to the preparation of witnesses. So we promise we will get you out of here on time. So I'm going to go somewhat quickly, but there are investigations almost always come in through an individual filing a charge of discrimination. However, there are two other types of investigations that are worth knowing about. One is a directed investigation that's permitted under these statutes, the Age Discrimination Law, the Equal Pay Act, and GINA. That means that a district director can initiate an investigation, and that would require some information to do that, but it can be, triggered. There are specific procedures for initiating that. And sometimes you see that if there's a charge that has class implications, but that charging party is represented by private counsel, somebody in the office might say, okay, well, let's investigate, but let's make it separate and apart from the existing charge. There's also what's called a commissioner's charge, and those do not happen very frequently. In fact, we just looked at the charge statistics on that, and maybe every commissioner, there are 5 commissioners, has approved 1 or 2 in the last year. So it is pretty unusual, but it can happen if one of, somebody from a district office makes a request and says, okay, I think this is something that we should be investigating. We don't have a charging party who's come forward on this issue, but I read about it in a newspaper, or it's implicated in this other charge I'm working on, but that charge is about to resolve. So that wouldn't be a good vehicle for the investigation. So there's specific procedures on this. It's very rare. It has to go to a commissioner and be approved by a commissioner, and then it is, proceeds as an investigation. So let's talk about conciliation. The EEOC is statutorily required to attempt resolution before it leaves the agency if there's a cause finding. And this happens whether the EEOC is going to bring suit in its own name or whether it's just going to be a cause finding that the charging party is given and can do something with. This is the last attempt to get a resolution that is private. Now, I have seen more and more press releases on the EEOC's website announcing conciliation. That is not required. That is done. I am assuming that is some sort of deal that is worked out because the EEOC by statute is not allowed to disclose that type of information without an agreement. So that might be an ask that is part of the conciliation process. But just know that, generally those are not revealed to other people, which is a huge incentive to conciliate. There was a Supreme Court case back in 2015, and the folks on this call, if you were practicing or involved in this area of law at the time, you'll remember it very well because this used to be an issue that was a motion to dismiss on a regular basis when the EEOC filed suit to contest whether or not it fulfilled its statutory obligation of conciliation. And some circuits read a good faith obligation into that conciliation requirement. But what the Supreme Court said is, no, it's largely in the EEOC's discretion. It has to attempt it, and then review is very narrow. The EEOC has very broad discretion to determine what kind and amount of communications it has with employers. And what I'm seeing, since that time is, you might ask for information on back pay or mitigation, which would go, I think is a very reasonable ask when you're in settlement negotiations, and that may or may not be provided to you. So it's a tough, conciliation, if the EEOC is eyeing a case for litigation, can be challenging because there really is no method for review. So the mechanics of conciliation, you'll get a letter of determination, which tells you the reason for the cause finding. You will also get a conciliation agreement outlining the remedies. The EEOC will always seek injunctive relief because that's part of its statutory mandate. It'll also seek damages. Oftentimes, if it's really interested in the case, it will seek damages up to the statutory cap. Whatever that is based on your employer side, okay? So strategic considerations and conciliation, you're likely to have a large initial demand. I think it's usually worthwhile to at least test the waters and see if you can get, have a couple of rounds to get to something palatable. The agreements are confidential, as I said, and you can likely get a separate release for non-EEOC matters. The EEOC only covers anti-discrimination laws, but with former employees, you typically want a general release of all other claims that could have been lodged. Types of injunctive relief you might see can be a claims monitor, specialized training, policy changes, all sorts of different things. There can be a claimant fund set up to distribute funds for people who come forward. You sometimes see that in very large cases. Okay, so conciliation has failed. Now what? And then this is the point where there can either be the plaintiff can file a private lawsuit, or the EEOC might sue in its own name. So you would think about, are there any, initial claims that you could bring in a motion to dismiss, both jurisdictional, what Veronica said earlier, maybe the charge didn't pen for 180 days. Now that's not going to get you out of a case forever, obviously, but that could get you back into the administrative proceeding and maybe get a confidential settlement in the agency. You can also think about whether a charge was timely filed. And, sometimes that is not always apparent until you get the FOIA documents or the Section 83 documents, and you see the initial communication with the EEOC could have been sufficient to constitute a charge, but it might not also be, and you don't have that information until you get the file. You also want to think about early settlement. Do you want to proceed before a magistrate judge? Lots of different considerations. And just very quickly, litigating against the EEOC, there tends to be a decent amount of written discovery as well as depositions. It's not like litigating against a private law firm where there are certain, financial constraints on, attorney's fees and things like that. There's no billable hour requirement. There's no, not juggling multiple external clients. And settlement can be challenging for different reasons than it is when you're litigating against a private litigant, because there are going to be a lot of pieces of non-monetary relief. And I, have seen deals either stall or blow up completely over things like the use of an independent monitor to receive complaints of harassment, the length of the consent decree, that type of thing. Any case that the EEOC brings is going to be resolved through a publicly filed consent decree that will outline all of the, both the monetary components, but the non-monetary components. And then litigating systemic cases against the EEOC that can last 5 to 10 years, you'll almost certainly need either an ESI expert or in-house expert. You will likely need other types of experts in terms of liability or damages. And you might want to consider bifurcation. So that's commonly done in pattern or practice cases, where the first stage is liability, the second stage is damages, and each side gets a certain number of depositions. So we want to end, and then we'll stick around for as many questions as you have on future trends, sort of trying to read the tea leaves just based on what we're seeing in these publicly filed strategic enforcement plans, what we're seeing in the litigation the EEOC is bringing. Number one is the focus on AI algorithmic fairness. That is been a top priority of the EEOC, and we saw the first lawsuit was filed in 2022 where a company was using AI to automatically screen out men over 50 and women over 40 from applying. So that was, the EEOC brought that as a lawsuit. Vulnerable workers, including immigrants or any other, particularly vulnerable group, is always of high interest. We're going to continue to see, I think, the EEOC come up with creative ways to try to investigate and eradicate wage violations, which are, can be difficult because people really generally don't know what other people make. So employees, don't always know that there could be a violation. We're starting to see COVID litigation. That's going to be really interesting as it makes its way through the pipeline, especially remote work as a reasonable accommodation. So that's something that we saw a lot of in COVID. And now we're seeing a lot of employees say, well, you did it for 2 years, so why can't you do it now? That is going to be, I think, one of, the top, pieces of litigation and guidance that we see in the next couple of years. And we see the EEOC collaborating a lot with other agencies, Department of Justice, OFCCP, Department of Labor, to try to really maximize its reach. So I think we'll continue to see that over the next couple of years. So I know that was a lot to cover in an hour. We hope that you found that helpful. And Amy, I don't know if you have any questions for us.
Yeah, that was so much information in an hour. Thank you both so much. That was really, really helpful. We did have a couple of questions that were submitted ahead of time. Looking them over, I think you might have covered all of them. Tell me if you did cover this or not. I think maybe one question that you didn't was, does HR need to give a federal government background reference request more information than I give normal employer request? Did you cover that?
No, so that's really, I would say that's not really in line with this particular topic. So we did not unfortunately cover that in the presentation.
Okay, yeah, that's okay. I think that everything else, this one says, has the timeline for investigating a case changed?
So that's a really good question. We are seeing that cases take longer and longer, and the EEOC, I don't know if it's attrition and not being able to backfill, or remote work, or it's not an increase in charges as we talked about here, but we are seeing that things are just sitting forever and ever and ever. And then also we have a lot of charges that are getting, we're in Maryland, so they get pushed to the Maryland agency or the local agency if it's a county where there is a local agency. So the EEOC is trying to offload as many charges as possible. So I think if you don't hear, no news is good news when you're at the EEOC.
Mm-hmm.
So that's a follow-up to Kelly's question. She says, does a year feel like a long time for no correspondence? And it sounds like, no, it's not.
No.
And that was the MCCR, I think, which is the Maryland, corollary to the EEOC, but I don't think that feels like a long time.
Okay.
We have somebody who asked for general tips or best practices for litigating once the matter reaches trial. So that is, I think that's a very, I think that's a great question. It's a very specific question. If you want to reach out directly to me, I'm happy to talk about that. I think that's would be very specific to the type of case and the posture where you're in.
And I did put in the chat below Lindsey and Veronica's direct emails, so you can reach out to them about this. And I also stuck the credit codes in there, so you guys should have everything you need. Thank you both so much for doing this. This was so helpful, so much information. In the follow-up email, I'm also going to put a link to that new poster that they referenced, so everybody has that most updated one. And I think that covers it. Thank you so much.
Here's one more. With states that have pay transparency laws, will there be any change in how the EEOC behaves? So the EEOC follows the federal law, so you would not really see the EEOC adopting what the individual state is requiring. An example of that is medical marijuana or recreational marijuana. It's still illegal at the federal level, so the EEOC takes that stance. I don't think it would be any different with the pay transparency laws, but if you have state or local agencies, I would expect them to enforce those laws. So, I mean, you certainly need to be in compliance with the state law if your state requires more than what the federal law does, but I don't think you would see a difference at the EEOC level, if that makes sense.
And if there's ever a question, it's always a good idea to contact your counsel.
Yes, absolutely. Well, thank you all so much for attending. It was a pleasure being here with you, and we hope this was helpful.
Yes, thank you so much.
Thank you both so much. This was so helpful. I hope everybody has a wonderful afternoon, and we will see you next week for the Secure Act 2.0 webinar. Thanks again. Bye-bye.
Yeah.